My name is Siddiq Savarwal. I'm here to present on the topic liability of auditor cited on the practical case on the course H16026 Audit Assurance and Compliance with my four friends. And when you're studying the liability and its type, when you use the word liability in the prism under accountant's liability, we understand it in context of various types of risks that arise in the course of auditing works. The three types of risks. The risks are inherent risks, the control risks, and the detection risks. When the risk is determined, we follow by two types of liability, which are criminal and civil.
My name is Simran. I am going to talk about the criminal offense versus civil offense. An auditor is found guilty of criminal offense if he is found to have breached the laws that are in force in any country in which he currently operates. Take for example, breaching the securities law by carrying out securities transaction based on insider trading information released by the audit client formed for the personal interest. Next, I am talking about the civil offense. Coming to the civil offense, auditor may be thrown at risk for non-complying with laws and regulations that are to be directly employed in the conduct of audit. So here we can have two laws that impact the auditor performance directly. They are contract law and tort law. Under the contract law, an auditor can be sued for simply negligence, while under the tort law providing higher level of negligence required, which is also referred to as a gross negligence. So gross negligence means intentional disrespect of law without having intention of harming anybody. Thank you.
Good morning. My topic is drivers of the auditor liabilities. So the bottom line is the strongest internal control and even the result of auditing procedure which cannot be prevent instances of the risks, and thus there is a large scope of risks in this profession. Some instance of changing regulations and also been seen increase of the risks, charging with the liabilities of the government, regularities, other parties. We can example of recent law which is called an Obamacare, and the teaching the technologies era has been considered the significant risks of error, but it has been increased risks to the auditor with the use of online payments, advanced technologies, etc. Thank you very much.
Hi, I'm Sakshi and I'm here to talk about the fact of the case. So during the period 1990 and 1997, the business of the firm was profitable and they demonstrate an enhanced picture. Its principal officer, Gert Dumsky and Maren Gottlieb, started mistaking the financial records of the firm. In late 1997, the auditor became known of the intentions of fraud prevented by the officers to report inflated profits to the public. Instead of bringing such practice to the notice of the relevant authorities, Deloitte discredited to them and neither resigned nor took any such actions as would be accepted in such circumstances from the professionally competent auditor. Rather, Deloitte firm assisted in preparing press release that included misrepresenting by Levin's officers about firm's profitability. It approved such release and also served comforts letters to help Levin raise funds by the way of debentures underwriting of around $125 million. Thank you.
Hi, myself Bianca, and I'm going to elaborate the consequences of this case. The case faced the court at different levels of court, and they. The trial court upheld the claims of special receiver and found Deloitte negligent because for failing to perform its duty with due care to protect the interest of various parties involved. Then the Justice James J. consequently awarded damages of around $84.75 million. At the Genesis, he declared an award of $85 million, which was heightened to $118 million to include the interest cost on original damages. Then later on, Deloitte challenged his case in the appeals. And he said the lawsuit essentially be filed by the creditors in reality and not really by the corporation. Then the Justice Blade rejected his claim because by saying he had no issue conclude the losses that were facing by the Livent, and he also declined his argument by argument that the company has no right to complain against him because the fraud was conducted by the one of the executive of the companies, but because it was the legitimate party complaint. Thank you so much.
Hi, I'm Manish. So till this time, we were discussing about the case of Deloitte and the auditor's liabilities and all the others business laws that determine the auditor responsibility and the consequences. So after the whole case, there was huge impact on the industry because this case becomes so famous and the concern for all the auditor community. So it also dealt with the auditor negligence and people started having less trust on auditors. So all these auditors, the responsibility was not performed as per the standard of auditing standard. So the impact was the reputation of the auditors was degrading day by day, because they were failing to determine the detection risks, inherent risks, control risks, or if they are finding the risks, then also they are not taking proper consideration. So either they are supporting the executive for exaggerating the profit statement and also the exaggerating of material statement. So nowadays there is a decreasing reputation and the mistrust on the auditors auditing profession, directly linked to the growing cases of auditor negligence all around the world. So after this case, we found out that the auditors should have a proper auditing procedures and standards, so that the fact stated will be less likely to have some fraud in it. And because the auditor are the one who check the statement of the company, it is true or false, and they are the one who take the veil out of the statement or the fact of the company. So at the end, we determine that if we become an auditor, we have to always follow the procedures of the auditing standards. Thank you.